People versus Prentice, case number 235153.
So she's running a little bit late. She called me this morning and then texted me.
People versus Jessica Moore.
Let's go check the hall. I didn't see my call up.
All right, this is file number 245320.
I think you're ready to get Ms. Moore, because Ms. Moore is not present following the hall entries.
She been in contact.
No,
She failed to appear on 10/10/24, and this was the next hearing date that we did a show cause at the time we're asking for a bench.
Mr. Gerber, anything you want to state?
for the record, Judge, I haven't been in contact with Ms. Moore since that 10/10/20. For a motion and status conference with the day.
Okay, the court will order that Ms. Moore's bond be revoked. The court will sign that bench warrant once it's been presented. Once Ms. Moore is arrested and brought before the court, proceed further in her trial. Versus William Beck, case number 245313.
Yeah.
Can you all remember?
All right, this is the date and time set for sentencing hearing in this case. Mr. Beck, you had a chance to send a report to Dr. Gerber about that. Mr. Gerber, are there any additions to the corrections?
No, Judge.
Yeah, this is the story. Guidelines.
No.
Scope for the people have any additions, solutions, or corrections. Challenges to this one. Anything on behalf of people for out? I'm sorry, did you have any victims that were addressed?
She is present. She did
Scope, anything you wanted to say?
This case is a struggle because Mr. Beck continues to come before this court. When he does come before the court, he does well. Then it falls off and we have these issues again. His substance abuse is an issue. It seems to lead to all of these different issues within the family dynamic. When I think of a domestic violence victim, I think of Ms. Mappy as a classic domestic violence victim. She even now wants to get back together with Mr. Beck. There's nobody sees that this is a volatile relationship and that substances and domestic violence riddle this relationship. You can look through his criminal history and see that he does well when he's on probation. The recommendation is for 2 years probation. I think that's appropriate. The guidelines are 0 to 9 months in jail. This is his third domestic violence, and I think it's appropriate to follow a recommendation for 6 months in jail with 2 days credit. Thank you.
Mr. Gerber.
Judge, Mr. Beck is 37 years of age, no prior felonies. Mr. Beck, while this case was pending, completed a 26-week course. I think he doubled up and got done sooner and much faster pace for a spousal abuse program. So he successfully completed that. I don't have a certificate saying that it's completed. I have an email from the person that did it, indicating that it's completed. Get something and I think received it. I do have confirmation that did it. Mr. Beck has provided numerous AA-related. I don't know if the court wants to see those, but they're just doing the pendency of this course. He's attended AA. He's not AA-related programs. And he's
What's an AA-related program?
So he did the spousal abuse with Mr. Benjamin.
Okay.
My understanding is Mr. Benjamin is actually the agent of the Department of Corrections who addresses the men who are in this situation with domestic violence, and it's a program created for that purpose. So he did that. He's out of Grand Traverse County. And then AA would be part of that program. He attended AA, so he maintained sobriety. And but I think they work hand in hand. So he has to work through the program that he's working with Mr. Benjamin and 10 substance abuse by way of the AA to have both of them work together when he's done it. So he's attended AA, he's completed the 26-week program. I think he was doing on the phone or by telehealth on the weekends with Mr. Benjamin. So he has taken those steps. I don't think in the past Mr. Beck has done any of those things. He's done probation, he's followed the rules of probation. I think this is the first step Mr. Beck has gone above and beyond and engaged in some additional services prior to even sentencing. Because I think this is for him to understand that this series is how most of the issues are on substance related. So Mr. Beck can curb those issues now at 37. These guidelines slowly creep up. He loses in prison if he continues on this path. I think Mr. Beck is taking some steps to curb the behaviors. I would simply ask the court, in light of what Mr. Beck has done, to deviate a little downward from the 6-month jail sentence recommendation to more of the middle of the guidelines, which should be about 4.5 years. I think that is very fair with Mr. Beck's situation. He understands there's going to be jail. He understands this punishment. I know he's apologized to Mr. Matthew. There's a separate mental abuse case that's also a family court. Orders entered in that court for co-parenting or both of them charged together. My understanding is that is going well. I haven't heard anything negative about that either. So if we can move all the steps Mr. Beck has taken, that a 4.5 month sentence is more fair in this matter. Certainly he can be on probation. As that the court is deviated slightly.
Thank you, Mr. Beck.
I feel bad for what I've done. I realize bad road. As soon as I got released, found the AA meeting as soon as possible. I it's taken 2 months of my life. I've got a 3-year-old. Nobody deserves to be treated. This is so I'm happy with my decisions to finally go out and do the steps yourself. Finally. The support system. No, so that's actually they last a lot of people don't know their lifetime. Like, still taking something negative to do it. It's just do the best I can figure out. Also got because I was doing substance abuse classes before. I was on the soul. Figured doing the counseling is long term.
All right, thank you. I did review the pre-sentence report, so I'm familiar with the incident that happened in this case. I'm also familiar with your background and your circumstances based on the information report. Taking all of that into consideration, along with what the lawyers have been saying today, there's a couple of things that stand out to me. number one, I think it's definitely positive that you're seeking help with treatment for this. This has been an ongoing problem for you. My count, looking at the record, this is your seventh assault crime charged with domestics and assault and batteries. And so this is clearly an issue that you had your entire life, adult life at least. And it's something that's not going to go away on its own. You need to do it through willpower, you need to help do that. So I think that's a positive change that you're making today. The negative, of course, is this is your seventh assault crime. And continuing these crimes. You've been on probation 8 times prior. All of those terms, whether they were successful or not, haven't resulted in any kind of change in behavior. So continue. That's all offenses. And in this case, I think it's made worse by the fact that there was a minor child present during this. It's well accepted within the scientific community that children, it's these kind of things. It's a continuing cycle. Those children are more likely to be offenders or victims of domestic violence when they witness it as a child. So this isn't just about the adult victim in this case. I think there's a minor victim in this case as well. Right? You say no deserves to be treated like that. No child deserves to have to witness this. So, given that you've been on probation 8 prior times, I don't view it as appropriate in this case. I think it doesn't make sense to me for resources in terms of probation. It's not clearly not working. That doesn't mean that you shouldn't seek treatment for this on your own. You're free to do that. Nobody has to wait for a court probation force them to do that. If you want to stay out of jail, that's going to be your best interest. But I'm not going to keep putting you on probation. In my view, this is a situation of strictly calls for punishment, consequence, and for the deterrent effect. I think it's important for people to see that it's assault crimes, in particular, domestic assault crimes. Guidelines in this case of 0 to 9 months, given your actions in this case and prior history. It's at the top of the guidelines is appropriate. Conduct in this case provides punishment review and return effect. So the court is going to sentence you to 9 months in the Crawford County Jail. You have credit for 2 days served. The court is going to order that they victim's assessment of $130. Court costs of $325. Attorney fees of $350. $68 state costs. You have the ability to seek appeal of this sentence. Rather than
Yes, just for the record, Mr. Beck does have his about 80%.
Mr. Beck, you are going to be investing time at this time.
Just for the record, you did give me 2 days, but
I
didn't.
This is not here yet.
Ready, Mr. Ferguson.
I'm just looking to see if it got added to the systems. Mr. Curtis, you come up to the podium there, please. We're on the record in People versus Curtis, case number 235165. I'm presiding over this file today here on behalf of Judge Hunter. This is set for an arraignment on a technical violation. The record should reflect Mr. Curtis is present here in the courtroom today. Mr. Mertz here representing Mr. Curtis.
I am Judge. I was appointed to represent Mr. Curtis with the arraignment, but I'm also appointed as underlying defense. The conversation we have this man, Mr. Curtis would plead to the count one that violated Mission 2. Excuse me, did use the substance. It's a technical violation. Mr. Curtis also says that the matter was originally assigned to Judge Hunter and ruled the resolution he would waive the sentence and ask for the meeting sentences and have two sentences of the original Judge Hunter's sentence.
All right, thank you. Mr. Curtis, you had an adequate opportunity to talk to Mr. Hermer about this. And is that how you want to go forward?
Yes, sir.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Curtis, you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yes, sir.
You understand that by pleading guilty, you're going to be giving up that, right?
Yes, sir.
Also, the maximum penalty, because this is a technical probation violation, you understand the maximum penalty. With that in mind, what is did anybody threaten you with anything to get you to plead guilty?
No.
Did anybody promise you anything? Does anyone, pleading guilty because you did violate probation?
Yes, sir.
Pleading guilty today. Back on, well, this was yesterday, November 6th of this year, you were on probation here in Crawford County, is that correct?
Yes, sir.
And were you aware that one of the conditions of your probation was that you were denied use or possess any controlled substances unless prescribed?
Yes, sir.
On that date, did you use
I use
okay. The court finds that your plea is knowing, voluntary, accurate, or dissatisfied as a factual basis to support a finding that you violate your probation is alleged in the technical violation. Accept the guilty plea. Mr. McDowell,
Good, I just recommend you get to these jail. Try to work this.
Good afternoon.
Mr. Curtis, anything you want to say?
Use a mistake. Stayed for a long time and mistake. Go back to just some classmates. Do what I have to do. Take responsibility.
All right, I think it's an appropriate penalty. This is a technical violation based on the underlying charge of this possession of a weapon or attempted possession of a weapon. Or finds it's important. We've given that underlying charge and both substances. For that reason, decided the opposite. So I find that a 15-day penalty is appropriate for the sentence to Crawford County Jail for a period of 15 days, with 1 day of credit. And you have the ability to appeal the sentence.
Yes, Judge, Mr. Curtis has a lot of paperwork. He's acknowledged Mr. Curtis.
Thank you. Mr. Curtis, you're remanded to the custody.
Thank you, sir.
People versus Prentice, case number 235153. Mr. Prentice, you come up to the podium. Like that, Mr. Prentice, here in the courtroom today. Mr. Prentice, you're here based on show cause for alleged probation violation. It alleges that on or about September 30th of 2024, violating position 2.4 of the probation, and that you used amphetamine. If you understand why you're doing this. A couple of things I need to go through with you with regard to your rights. First, you have the right to have a hearing as to whether or not you violated your probation. You also have the right to have an attorney present in the subsequent proceedings. If you can't afford an attorney, he can be appointed for you. If you are found guilty of this violation, because this is a technical violation, maximum penalty you can face with 15 days in jail. You understand all these things. Did you want to hire an attorney? Did you want to see qualified or appointed? How did you proceed? We do have court-appointed counsel present here for today. Would you like to have a chance to at least talk to them about how you should act? Thompson, can you always refer me? So this here on a standby basis as arranged as counsel.
Certainly, you have an extra copy. Yes, you have to.
We'll pass this case, Mr. Prentice, just let Mr. McDowell know.
All right.
Short, but it seemed long. Yeah, it's only like 8 years, I think. Show house here.
Oh, that's how is it all this?
Jury duty. They haven't filed their form.
Oh.
They're not defendants, they're like regular people.
Oh, I thought it was like family court show. I was like, oh my God.
Oh.
So what does the judge do in situations like that?
Make them fill out their form,
While
charge
they're here,
them $50.
or not filling it out when they get them?
Right, because they had to go send an officer out to the house to go personally search.
Ah,
And if they fail to show up, then they get a warrant.
so they're serious, like this is.
We've issued tons of warrants for people who don't fill out their jury stuff.
Oh,
Sorry, Sarah. I kind of came together. I wasn't
No.
expecting that, and then I
I
should have told
appreciate-
you. I just, my mind was thinking 100 different things.
I appreciate the heads up before we got too rolling.
I was sitting there, I'm like.
Run up there.
I forgot too that.
That's his fault.
I forgot too, but I told you, we're going to do immediate sentence, myself and the judge. So we're gonna wait, judge. I told you while you were walking that way, but maybe you didn't hear.
Nope.
Yeah, I didn't think,
You don't see eye contact.
yeah. That's all
Or,
right.
yep, got it.
It's no big deal.
Instead of you're a liar. Oh, I didn't.
She'll get an acknowledgement from you if I hear you.
You know, you.
Oh, yeah. Just-
That's literally like.
We're ready to practice, Sarah.
All right.
All right. So what are we
Ready
doing?
on until whenever everybody else is.
We have a bunch of
Playing
people here.
sense. Start as quick.
Very good.
Oh, it's in.
Okay.
Somewhere. in
Just
here.
a note, so-
Yeah.
I let it go into a second.
And.
That's why.
You see,
I'll probably report to you.
Okay. Get out of the. Very used to me.
matching. That is. Yeah.
Somebody came up with a
I have a lot to work on.
Well, if it was truly from last night, which it does, that does happen, right?
Not that high, no.
Yeah, I mean, it was 4 o'clock.
The last night could have been 5 o'clock in the morning.
Yeah, there's no way he went 12 hours. Right, I guess, right. Just John? Was another gun.
See, you are coming to court today. See, you are coming to court today.
Yes, supervisor. Yes. It's good.
Bringing up big shoots today.
Couldn't do it without
Heavy
you.
hitters.
I work here.
Where's your suit?
Oh, they don't give me one. Said I'm not ready for it yet.
Soon though. Still got a little bit to learn.
You have to be over
Had to
30.
buy yours, huh?
You have to be over 30.
I'm almost there.
Do you have anything? I'm James Miller. Yeah. A lot of people attending, nobody's speaking.
The lobby's full. So.
Well, we also have Burmeister jury show classes, so
Oh,
I wasn't sure.
There's
who's all-
victims here.
Fun afternoon. When,
Afternoon will be busy with different people.
we just back in.
Board of canvassers.
I was talking
I
about the
think
board
we
of
do this for
Oh.
case, so.
That's
Gonna
like
have a
actually
lot of
worse than criminal
observers.
court.
Yeah.
Got a lot of observers.
Yeah, and the people that are brought in to explain why they did what they did for the election.
Review the process or something.
How do we pick who's on? Am I need to read?
The board of canvassers?
Yeah.
Yeah. I mean, they can't kick each other off and the commissioners appoint them.
What is wrong with that state? Like, I don't understand.
The law
So they
says
finally
they don't
called-
count the ballots until the last vote is in.
So they
Yeah,
have-
and they can be mailed, they can be postmarks, they don't start until Saturday. It's ridiculous.
I keep looking at it, I was like, where are the 35% of those that are
Luckily,
missing?
they did come down with-
Don't you remember 4 years ago? For those lawsuits in Arizona?
There's,
thought it was going. I mean,
Yeah.
I did.
4 years ago, I was all really cared about this claim.
No, actually, well, actually, like I said, Arizona.
Right, they were convinced there was.
Yeah, I heard.
An issue like, right, conspiracy.
Nevada was still not called yet.
Oh.
Yeah.
Yeah.
Alaska got called.
It did.
really,
Wednesday afternoon or something. That's all 3.
last time was probably the first one.
He's a-
It's not in my tree, so it's been a very long time.
He's got a plan on this system.
That's one of
It
those
doesn't
things.
matter.
He called it old swing states.
Oh, it does. I want to give
No,
it
it's
300.
fine.
Me too.
Well, he's probably gonna file 50 more elections to recount it. No, no, he's not an election system.
I actually thought that was,
Shocked.
I thought that would be the case, but it's still happening.
Yeah.
I thought, okay, because
Hope he's living in the
That
car
would-
until it gets
Yeah.
longer. May not make it.
Well, he's older than Biden was. Last election, he might not make it.
No, I was just talking about.
In general. He's 78. Not young.
Put them in, that's tough.
Watch him go.
He is a good help.
Yeah, there's no joke.
That would be in
Place for room 10.
I don't know if you're on it right now.
Huh?
He's gonna step in second. Yes, sir. You didn't go to some.
Yeah.
That were added on to the sentence. Thank you. All right, please.
Thank you, please. Try to like come forward, please. Okay, we're back on the record in People versus Prentice. Mr. Prentice, do you have a chance to talk to Mr. Thompson? Mr. Thompson, Mr. Prentice.
wishes to stand you today, as you said, about 60 days out. Recommendations, criticism, we have. And here for 60 days.
Mr. Prentice, is that how you want to use? So the court will enter a not guilty plea on your behalf today with regard to the alleged violation. Mr. McFell, is that correct? PR bond? That's correct. Okay, so the court will set this for a hearing date, although it's 60 to 90 days out.
That will work.
So you'll get notice of that date and time of that next hearing. But make sure that state prejudice. Okay. And then the court's going to set a personal recognizance bond in the amount of $500. Post that today. You need to make sure that you continue to appear for any court hearings and that by all the conditions. Okay. Mr. Prentice, do you have any questions? Mr. McDonald, anything else?
No.
No. Mr. Prentice. Oh. Mr. Thompson, are you ready on Mr. Gentile's case?
Yes, thank you.
Mr. Gentile, if you can around to the please. If you can have counsel put your appearances on. This is People versus Gentile, case number 245318, 245335.
You're a vote of the people.
Thank you, Jason.
This is the date and time set for sentencing hearing in this matter. Mr. Thompson, just so that you're aware, I did receive a number of statements, including victim impact statements along with letters on behalf of your client. Mr. Gentile, have you had an adequate opportunity to go through the pre-sentence report and Thompson about that? Mr. Thompson, are there any additions, deletions, corrections? Are there any challenges to the scoring guidelines?
Good.
So, do people have any additions, deletions, or corrections?
You're not.
Have any challenges to the scoring guidelines?
I believe it's for-
Do you have any victims that wish to address the court today?
There are several present in the courtroom, but none of them wish to speak.
Anything that you want to say on behalf of the people for allocation?
Now, this is probably one of the more difficult cases that I've worked on in my career. Because Mr. Gentile was an active member of the community. He comes from a good family. He has a good support system. All the things good in his life. And then this is just absolutely horrible. These are people who would normally not have contact with the criminal justice system. A lot of the people we see them all the time. We know them on a regular basis. I see them because they're here in our criminal justice system all the time. The victims of this case aren't like the victims in a lot of my cases. And that people tend to prey on the weak. And that's what happens with the kids. These are all outstanding children, from outstanding families, had supportive parents, supportive friends, supported their community, they're athletes. You know, and they came forward. When I read Ms. Bell's statement, I think she probably said it best in this statement, is that when it comes to children, I don't think there is any sentence that is going to take away their shame and their embarrassment. And when I'm talking about male victims, it's totally different than the female victims because we all know to look out for female victims. We tell our daughters, we see it all the time. But male victims, and in the cases where I have male victims that are in the teenage realm, a lot of times they don't come forward or they're embarrassed by their actions or think that somehow, they don't expect to be victims of crime at that age, the way teenage girls do. And I'm proud of the kids for coming forward. This is a terrible situation. Justice was in a position of leadership. He was in a position where he mentored these kids. He was in a position where he was a volunteer and the kids looked up to him. I realized when I read through the PSI how bad his substance abuse had become. But I think that the recommendation is appropriate. The guidelines here are 2 to 17 months. I think they encompass his behavior. I think the probation of 5 years that's recommended is appropriate. I think it is appropriate that he not have any physical, written, or electronic contact with anyone under the age of 17. That he does the sexual abuse prevention program, that he register on the sex offender registry, that he not access the internet without doing any NVOC internet use, and they'll be able to monitor all of his use during that probation period of 5 years. That he not use alcohol and be tested, that he not use controlled substance and be tested. And then the jail recommendation is 12 months with credit for 160 days. I really vacillated back and forth on whether or not this would be prison appropriate case and whether I would come in here and advocate for prison. I don't know whether serving 12 months in jail or 16 months in jail changes anything for Mr. Gentile. He has virtually no history of the criminal justice system besides his drunk driving case. So any amount of jail is going to be effective on him. You can tell by looking at him the effects that jail already has had on him. I think it's important that he is on the sex offender registry and he does not have access to children and internet is monitored. I think it's important that he takes the rehabilitation seriously and that he takes the classes. I'm hopeful that he can do all of those things to become a productive member of society and that this does not happen again. This was really just a series of very horrible decisions by Mr. Gentile. Thank you.
Mr. Thompson. anything on behalf of your client?
Yes, thank you, Your Honor. Obviously, when this first happens, this is an individual, before this happened, this first happens, your emphasis is how bad and scary and terrible the situation is. This book emphasizes the dangers and the harms presented here. But as I've worked with justice, as I've gotten into this case, as I've seen what happened here and read the description, I think there's an element of fortune. There's an element of fortune that justices slide the things he was doing that it didn't get stopped. Someone did come forward and that this did stop before it got worse. And I think there is an element of fortune here, which isn't to say there wasn't wrong moving here, but this could have gotten much, much worse. I think this code talks about the difficulties with teenage victims, with male victims. I think we're fortunate this got arrested, this got stopped. So if you look at substance abuse, the justice was engaging in this risky inappropriate behavior that he's engaging in, these inappropriate messages. I think it's fortunate against not. I think it's fortunate for justice. I think it's fortunate for our community and everybody involved. And then when I look at this probation regime that we're talking about, when he finishes his time, which he's done time. When he finishes his time, he's back in this community. These are very significant restrictions, not being allowed on the internet unless it's monitored, not being able to drink alcohol, not being able to have contact with individuals under 17, loss of his job, loss of his coaching position. I think what has been done here in this PSI is to put together a plan that would give someone, if they were properly motivated, had a proper amount of support, a chance to become a different kind of member of the community. Coaching it can't have a sole job. He understands that, but to be a productive member of the community, this individual who had drunk driving doesn't have a background of assault crimes, repeated assault crimes. Individuals come before your honor who've hurt people frequently, and this is a gentleman who is engaged in appropriate activity. And I really hope that we will look back on this in a year, and 2 years, and 3 years, 5 years, 10 years. We're saying it was fortunate that this got arrested when it did, that this stopped, and that justice was able to turn things around. I think there are reasons that they can turn things around. I think, first of all, the level of supervision here is significant. And this is a young man who does respect authority, does respect what the court says. He's going to respect his probation officer. I can tell you he's probably the most respectful client I've ever had in terms of respecting the court, respecting the authority of the law, respecting everybody involved. He didn't mitigate this, he didn't badmouth victims once. He's taking responsibility privately, because how this process plays out, he's taking responsibility for the we have to work out some things legally, it takes a minute. He didn't force anything unnecessary on anybody in this case. He took responsibility, he's standing here taking responsibility today. I think these terms of probation are very appropriate. I think for an individual who hasn't been time before, so that's strong ties to the community, it makes sense to consider a jail sentence. He's got family, really good family. He's got people in the community. He's got ties to the community. And yet he is someone who respects the law, respects what he's going to be told to do by his probation officer by your honor. And I'm hopeful that in 5 or 10 years, we'll look back and say it's fortunate as bad as this was, it didn't get worse and it turned around. So that is my hope. So, thank you.
All right, thank you, Mr. Gentile. Anything you wanted to say?
So I just want to say thank you, Your Honor, for letting me speak today. First off, in other words, I'm sorry. And what I say here today will never be enough. I am truly disappointed and disgusted by my actions. I am sorry for the victims, their families, my family, and this community. I was trusted, looked up to, and looked to make a positive influence on future generations. I always wanted to strive to give back to this community that I grew up in. I started when I was young with little bikes, Redskins, Little League, and having over 100 hours plus in the community service. To my adult years, I've donated my time and money to coaching, supporting charities, and local events. Dream of mine was always to coach, because I had so many great cool models throughout my school years. It wasn't always about the wins and the losses. After that last pass, shot, pitch, or second in the clock, it's about what you take into society wherever it takes you. You learn teamwork, discipline, self-drive, communications, and so much more. Felt as I was a coach, mentor, friend, and off the field. I had numerous conversations off the fields with kids about future goals, short and long term, college plans, relationship issues, friendships, school problems, and various other appropriate topics. What he calls day to day about problems, mental health issues, and or maybe I was just a person who trusted to confide. I would explain life and answer any questions to the best of my ability. When I was working or coaching, coworkers, coaches, parents, and players would say I was positive, upbeat, social, and dedicated. Even with all the positives, it doesn't take away from the reason I'm here today. I failed as a coach, a family member, and a community member. I wish I could take it all away. And some of my downtime and the choices I made that are what led me here. No one fully responsible for the decisions I've made. Starting with breaking boundaries of even accepting friend requests that contacted people I was trusted to, as well as sending some rude messages. I made those decisions, now I have to deal with the consequences. I cannot take away what I have done. Not a single day goes by that I don't reflect on the choices I have made. Life is a precious journey that I jumbled up for someone. I let everyone down. It had a positive impact on me since birth. Things will never be as they were for the victims, all the families, and all for this community. But what I've done will always make people second guess, reevaluate, and leave the bad image in their head. I am only human, and have made mistakes in my life, not to this gratitude, but this choice will stick with me for the rest of my life. The judge has the final say on my sentence, and however long he imposes, when I get out, I will make better decisions, and I will make a difference to not only better myself, but the people around me as well. Concluding, from the bottom of my heart, I am truly sorry again for everything I've done. Thank you.
All right, thank you. Mr. Gentile, I did read through the pre-sentence report, so I'm familiar with very thorough description of the circumstances that bring you before the court here today. I took a lot of time to read through all of that information. There's also a lot of information there about you personally, your background, circumstances outside this. Take all of that information into account. This will be read through with great care. The statements that I have, victims in this case, obviously has a big impact on the court, determining when the appropriate sentence is, when to know how it's affected the people who are involved. And she needs to read the letters that were submitted on your behalf as well. Listening to what the lawyers had to say and your statements here today. Putting all of that together, my role here is to try to determine the sentence that's going to accomplish a number of different things. Number one, punishment for you, so that you understand the wrongfulness of your actions in this case. Deterrence, so that hopefully this has enough of an impact on you that you're not going to engage in this kind of conduct again, and so that other people in the community see that this is conduct that's not going to be tolerated as we dealt with. And then rehabilitation. The board has an obligation to look at ways, particularly in your case, someone of your age with limited criminal history. What can we do in terms of rehabilitation to prevent this from happening again? If you want the right track, so that you victimize again. And I think the court can accomplish that in a number of ways here. Number one, I think punishment is entirely appropriate. I'm sure that use of alcohol and other substances have a part to play in your actions. But clearly, one of the dangers of using alcohol and other substances is it has this effect of disinhibition. In other words, things that you might not do when you're sober, when you're not sober, you feel more free to engage in those things. And there's less self-control. And I think that clearly played a part here, but I don't think you can talk about that entirely, based just on the number of people that you contacted, the number of times that you contacted those children. So that the circumstances, not just soliciting pictures and sending things of your own, but soliciting specific acts and payment of money for those acts. To me, that's more than just somebody who's been drinking and self-control late at night. That's someone who's got some underlying proclivities and some underlying urges that they're having a hard time controlling whether or not they're using substances. And that gives me concern. It's one of the reasons why I think the long-term probation is appropriate. But I also think that it's grounds for the punishment, because I think that's not acceptable conduct, whether you're using substances or not. I think something that's been touched on here as well, the erosion of trust, position of trust. It's very important in our society, in our community, to have individuals who are trustworthy to be coaches. And kids can feel comfortable with, kids can trust them. But they're trusting, feel like they can confide in, they're going to be heard, and that adult is looking out for them. It's important for parents to be able to feel like they can put their children into the sports program and not be worried about what's going to happen. And these kind of actions can grow that within our community has lasting effects beyond this case. And I think that also deserves serious. We're in that position to trust. Now these kids in particular are going to have a hard time being able to trust coaches going forward. The parents are going to have a hard time doing that. And people who aren't involved in this case who hear about it more suspicious, otherwise might even withhold their kids from participating because they're worried about something like this happening. So there's a bigger effect that as well. In terms of rehabilitation, as I indicated, I do think there's potential for that given your age and your lack of previous criminal history with the appropriate supervision. I think the character letters that were submitted on your behalf speak to that part of it. Nobody is all one thing, and they have good qualities in some ways, but we have issues supervision over a long period of time. Possibility that you can develop those good sides and control the bad side is. I also agree with Mr. Thompson. I feel like just reading through this, that things were getting on the verge of going out of control between substances and your other proclivities that were far lucky. Was found out at the time it was. And I agree with the statements about the victims coming forward here, making this known as opposed to just letting it go, which I think does happen, particularly it's done through means of Snapchat, social media, where you kind of erase it and just kind of forget about it. I think we're all fortunate that it's involved here didn't do that. And that was brought to their sake, but Mr. Thompson said for your sake too. I think it's just headed in the wrong direction. It's going to go wrong, more wrong. Really quick. So I think again, it's such a positive thing that made this. So for all those reasons, I do think that the recommendation is fully appropriate. It provides for that punishment, provides for that consequence to you. That, but I also think it provides for the potential for rehabilitation, probation. So if the court is going to adopt that recommendation, the court is going to place you in file number 245318 on probation for a period of 5 years. You'll be required to register by statute with the Michigan Sex Offenders Registration Act. The court is going to require as one of your conditions that you not reside, work, or loiter within the student safety zone of 1,000 school. They cannot access the internet using any device unless it's approved by your probation agent. And you comply with all the other terms and conditions of probation. In that file, the court is going to order that you serve 12 months in the Crawford County Jail for credit for 60 days served. Crime victims assessment of $130, $30 per month supervision fee while you're on probation, or cost of $325, and $50, and $60, state cost of $136. This is the file number 245331. Also, 5 years probation, same conditions. As to that file, 12 months in the Crawford County Jail, credit for 159 days served. File crime victims assessment of $130. State cost of $68. Those sentences run concurrent to each other. You have the ability to seek an appeal of the sentence. Guidance you so appellate rights to
Receive it. Okay. If you wish to keep these two, if you wish to. Thank you.
Mr. Thompson, there should be one for 50 feet.
Right, misspoke anything further on this file for me?
No, thank you, Your Honor.
Mr. Thompson. Nothing further. Really very good custody of the county. People versus Joel Wright, case number 24536. Mr. Wright, present.
You're going to
Thompson is here on behalf of Mr. Wright. Record to reflect Mr. Wright is present during the courtroom today. This is set for sentencing. Mr. Wright, you had an opportunity to go through the recent report with Mr. Thompson. Thompson, are there any additions to the corrections?
No, yeah.
Jones. So, do people have any additional deletions or corrections? Jones is scoring.
Diane.
And behalf of the.
And I think the recommendation here is appropriate. It does build into it something that we have been doing, 90 days in jail, 3 days credit, inpatient after 30 days. I think that sort of balances punishment and goes through implementation. He had 2.7 grams of medicine. That recommendations were passed.
Mr. Thompson.
I do think the recommendation is appropriate. I think Mr. Wright was fine. To show. Gives a lot of show. Court is very familiar with the issues of substance abuse. Shape. Mr. Wright would benefit on the term rehab as suggested. That's an appropriate recommendation. Thank you.
Mr. Wright. I did read through the report, familiar with your circumstances and what happened in this case. I do think the recommendation is appropriate. You have to need for some treatment and probation. Is in terms of helping you work on this issue. That's what I will say, you're well aware of your past history. Running out of opportunities for probation. Looking at reports, this reflects that a number of terms of probation. Sooner or later, you're going to wind up with prison recommendations. So I hope that you take this as an opportunity to use some resources like inpatient treatment to help you with your substance abuse. Sounds like you've got a good job working out for a long time. Sounds like you've got a lot of things like so I hope that you take this opportunity when you if you don't, then back to the probation. That's not the way it goes. The court is going to sentence you to probation for 24 months, subject to all the terms and conditions listed in the report. The court is going to order that you serve 90 days in the Crawford County Jail. I agree with the provision for release to treatment after the first 30 days. Jail pay for the credit, successful that treatment on jail time. Right, assessment of $130. $30 per month while you're on probation. For cost of $325 and $68 state costs. You have the ability to seek appeal of this sentence.
Yes.
Councilman.
Mr. Wright, if your initial here, see this is a public rights. This was deciding it.
Burden for the custody of the county at this time to look into it. Mr. Coleman, please spot. Oh, yes. Let's take a short recess and we'll proceed once we get into.
All right, please.
Better on the new system. Last time we looked. I didn't.
We're on the record in People versus Coleman. This is case number 225050. The record should reflect Mr. Coleman's present here in the courtroom today. Executive Thompson, your appearance.
Sierra Coleman, the people.
Thank you, Your Honor.
This is the date time set for sentencing on a probation violation. Mr. Coleman, did you have a chance to go through the pre-sentence report and talk to Mr. Thompson about that? Mr. Thompson, are there any corrections that you made?
No, Your Honor.
Ms. Coe, do people have any corrections?
We didn't.
Ms. Coe, anything on behalf of the people for allegations?
I think the recommendation for 30 days. is credit and successful discharge.
Thompson?
Your Honor, I think this charge is appropriate. As the court considers certain this court responsibility. Some of the costs, perhaps the budget successful discharge would very well follow basically the section. Exactly the change. The extra 20 days in jail would ask the court to consider. I'm certain that it's a successful discharge. Successfully completed was only 2 weeks away. So that's where the consequence of that. Thank you.
Mr. Coleman, anything you want to say?
I do apologize for example, trying to be here. My vehicle broke down. I can't contact them. Last week, I just couldn't be here. Across the state to be here. I feel like I tried to do everything to get lost going on. So basically, the first is it's been a tough year.
Great. I read the report, so I'm familiar with that circumstance. And I'm sorry for your loss. It's difficult for anybody to deal with. I understand that's underlying issues that make it worse. So,
I do have quite a few clients that their jobs are open, houses are exposed to the beats. It's bad. It's just starting. Big compared.
yep, I understand. And I think the recommendation here takes into account some of those things, including someone in the background. I do think discharge is appropriate at this point on probation. And I do think there needs to be a penalty. And I think by not only for you, but other people who are on probation. I think 30 days is a fair sentence. I think it's conduct in this case. So the court is going to follow the recommendation, discharging unsuccessfully from the probation. Reserving fines and costs. It's going to be 40 days or 30 days in the property. You have credit for 10 days to serve. You have the ability to seek appeal of the sentence.
Sorry.
I will correct this.
Making sure it's within the policy and file.
I was held with city for 2 days. First time I was picked up.
Yeah, I believe that to be accurate, but that's notes, but I would not object to 2 more days for that.
So the court will allow for 12 days.
I usually hear you're going to receive these. It's not the same as filing an appeal. If you decided after reading it, wanted to file an appeal, you would use these 2 sheets that we do with, check those out.
Our next hearing is set for 11/15. The district court case sentencing people versus loss.
She's.
Okay, we're on the record now in People versus David Law. This is District Court Case 2417615. The record should reflect Mr. Law's present here in the courtroom today. This is set for scheduling hearing. If I could get Thompson with your appearances.
Yes, Your Honor. Dana Cheney on behalf of the people.
I think you know everybody was very.
Ms. Shady, did you have any victims that we should address the court today?
We do not have any victims here to address the court. She did have some wishes that she wanted me to communicate to you, is that she would like the no contact order to remain.
Anything else that you wanted to say for purposes of evaluation?
No, Your
Anything else you have?
Yes, Mr. Law is 37 years of age. He has been in a relationship with Amanda Hall for 17 years. Any criminal history, he hasn't any criminal history whatsoever. I know history with this kind of conduct. So understanding is there was some issues of infidelity that led to this. Was it right? No. The way he acted, was that right? No. Mr. Law was not intoxicated, was not under the influence of alcohol, drugs, and minor substances. And I've had lengthy conversations with this law because as a defense attorney, we see this usually with somebody who has some history, who's exposed to some sort of behavior, bar fights, and be brought to disorderly in public. Police officers or multiple police contacts with the individual that they're with. 17 years of zero history with this individual, this partner, and 2 kids. Resided and lived together 13 out of the 17 years. And it was just hard for me to come to senses of why and where this happened and how this could lead to such a situation as one Mr. Law dealing with Mr. Law and his family. He's not an angry person, he's calm, collected, confident in understanding things. It's just things just didn't happen. I'm still struggling with understanding how Mr. Law got up here. Again, I'm not negating any of that, but it's just that you don't see those behaviors that you can then tell your client, you know, this conduct, these patterns of this behavior, this history is what brought you. Certainly what he did here was brought it, but I just didn't have anything to go back on in the 17 years of relationship. Talking to both sides of the family, Saul's family, both parents still considering this your son-in-law, have that relation with him. His side of the family, his father has that relation with him. His father helps with exchanging the children, monitoring the exchanges, some children back and forth. My understanding of conversations is that these individuals are ready to get back and work through the issues. We're not asking them to contact me to modify it. Mr. Law would like to enter into a religious kind of treatment. He's indicated that the Calvary Baptist Church has a pastor who provides domestic violence and couples counseling related therapy services. That's what he intends to at least reach out to start. At some point, he would have been asked to modify. and she's at a point where going through some issues and get to a more comfortable position to ask the court. If the court remembers, Mr. Wall was on the sling previously. He's seen a doctor since he still has shoulder issues, so he's not working right now. So he tends to get it when he deals with the shoulder injury that he has. He has no objection to being probation for a year. We would ask that he grant him the deferral status, and then during the course of probation, he would look at payment to pay his fines and costs. He has no issue with completing the program. If the court wants him to do that, then he would ask that he's responsible to count whatever he does with the Calvary Baptist Church towards the. Then I don't have to report the judge. It was a 45 days jail, right, but he has no business, so that's that. Suspend that at this point is a recommendation, 1 day of Friday, I would ask them to 9 days. They violate the bond, did 9 days, bond violation, excuse the time, it's correct. Other than that, I think it was very unlikely to see that. Indication of taking steps to probably done himself.
Mr. Lott, anything you want to say?
I just wanted to say that it's totally out of my character to do what I did that day. And I don't know what overcame me. Like you said, the infidelity thing, and you're trying to work out, you know, the living situation. And I was in between staying with my dad some of the days and staying at my house the days that my significant other went to work. And I really don't want to have the no contact order lifted until I go see the pastor a couple times just to figure out what happened, you know, mentally with me, and maybe I need to discuss with somebody that's not related to me or somebody that I don't know, you know, just to get some of these feelings off my chest, you know, just because I don't know how to take that, you know, we've been together for such a long time, and you know, it's kind of like we work on things, and other times it'll be a complete mess. And I do foresee maybe possibly eventually being back together with me, because we've been together for such a long time. We have children together, and it's really going to hurt me more than anything if I have to go to jail for 45 days, is to be away from my children, because I help them out so much. Other than that, I'm super sorry. I wish I could say this all to Amanda. Of course, I've been in contact. And when I broke my bond, I did try to go over to the house. I didn't go in. We didn't really have any contact, any physical contact or anything. But I wanted to tell her, you know, how I felt. And I haven't been able to talk to her other than through my father. And as far as I know, that she didn't want the no contact order anymore. I don't know. But I did tell my dad to tell her that I would like to seek counseling before I even, you know, to see her. I'm sure a lot of emotions are going to come back to me when I see her. Not a negative way. But I have been with her for over half my life. I love her.
All right, I am familiar with the facts of what happened in this case. I did review the police report. So I get an idea of what the background is, taking that into account along the way. So 30 minutes statement today, as well as the prosecution side of things. Number one, I do think the deferral is appropriate. I think giving you the opportunity to have probation and have this public record, given lack of prior history, I think it's an appropriate opportunity. are, as these things, these types of situations arise, where those emotions get inflamed and they act in ways that they don't act. And that's why the legislature provided those referrals. They show that this was out of character by being on probation for a period of time, successfully completing it, recognizing that ability to move on to this next situation. So I hope you are successful with that. I think it's an opportunity to do that. However, this was a serious situation. This was a violent encounter, which is concerning to me. It's also concerning that the kids were around for this. They saw what happened. I mentioned this in a case I had earlier today. When children are witnesses to domestic violence, there's a lot of data to show that they go on to be victims or perpetrators of domestic violence themselves later in that kind of environment. Witness that. It's incredibly harmful for children. And so the fact that you engage in this kind of present cause concern. So I do agree with the assessment that it's a punishment. It's in order for that it's an appropriate sense of how here and provides the punishment for you as well as the deterrent, so that people see that you stuff seriously. So the court is going to sentence you to 45 days. And we're going to allow 1 day of credit. While the court can impose an additional penalties on violating the bond and might be penalties. So bond violation. This is separate conduct. Bond violation one. Since this is a separate instance. And the court is going to place you on probation. You do have the ability to seek an appeal of the sentence. If you want to appeal the sentence about that. Case. If you have any questions about that, Mr. Shady.
Nothing further from the people. Thank you.
Thank you, Mr. Lawyer.
Yeah, I have a broken scapula, so I can't really raise my arm. But I can put it down.
The court will be in recess.